country will implement an agreement in its own unique way. The issue in question about the significant challenges for the compliance with the emission reduction targets in each country are mainly due to the variation between monist and dualist systems used across nations. Monist system and dualist systems are fundamental concepts in international law that describe the relationship between international and domestic legal systems. This video aims to examine how these differing legal frameworks contribute to challenges with implementing international agreements such as environmental agreements, exploring the legal and practical challenges each system faces in aligning domestic law with international law. There are a few main differences between monist and dualist system on how they implement international agreements. Monism, in its most basic form, holds that international law and domestic law form part of a single universal legal system. Hans Kelsen, monism's most prominent proponent, believed that there existed a hierarchy connection, with international law being superior to domestic law, and therefore it takes precedence in any dispute between the two laws. For example, a monist state would be the United States, as Article 6, Clause 2 of the United States Constitution provides that treaties are the supreme law in a country. International law will automatically be part of the domestic legal system and does not require additional steps for implementation. On the other hand, a dualist system treats the international and domestic system of law as separate and independent. In this system, international law is viewed as the law between states, while national law is the law within a state. Therefore, international law only has validity within the domestic system, if it is authorized or incorporated by a domestic law. This means that each international treaty will require a separate legislative act to incorporate an international agreement into domestic law. International law is a law between sovereign countries, while domestic law applies within a country and regulates the relations of its citizens with each other, as well as with the executive of the country. According to dualist doctrine, neither order has the power to create or alter rules of the other. An example of a dualist state would be the United Kingdom. In the UK follows the principle of parliamentary sovereignty, which means that the parliament is the supreme lawmaking body. As such, international treaties or agreements do not automatically become part of the UK law when they are ratified. Instead, Parliament must pass a legislation to incorporate them into the legal system. For example, the passing of a Human Rights Act 1998 to ratify the European Convention of Human Rights, ECHR. Moving on to the legal challenges, coordinating domestic legal systems with international law brings particular challenges in both monist and dualist systems, as each system will encounter legal and practical challenges that could hinder the enforcement of the international law. Critics argue that in reality, for a monist system, there are often conflicts between international and domestic law. This shows that it's difficult for international and domestic law to coexist smoothly with one another within a unified system. This would often result in incomplete or inconsistent domestic implementation of international law, even after the agreement is signed between countries. For instance, the US has domestic policies on the death penalty. The Federal Death Penalty Act 1994 explicitly outlines the offenses for each of the death penalty that can be imposed under federal law. Although US is part of the International Convention of Civil and Political Rights, which has a second optional protocol that aims at the abolition of death penalty, its domestic law on the death penalty directly conflicts with the treaty's objectives. This inconsistency will result in part of the convention being blocked from the enforcement within the country. For a dualist country, the legal challenges that they would face is the delay in encompassing international law and domestic law. Due to the fact that this system, to incorporate international law domestically, the parliament would have to pass an enabling act. For example, in Ireland, Article 29.6 sets out a clear statement of the effect of international agreements in domestic law, which emphasizes that Ireland incorporates the dualist approach to application for international law. Before 2003, when the ECHR Act was incorporated in Ireland, Irish courts could not enforce the ECHR directly. In the case of Lawless and Ireland, the applicant claimed that his imprisonment under the Offences Against State Amendment Act 1940 violated the state's obligations under the ECHR. The court ruled against him primarily because Ireland had notified the Council of Europe that it would temporarily suspend certain obligations from the ECHR while using the 1940 Act. This case shows that before the incorporation of the ECHR in Ireland, the dualist approach limited the domestic impact of ECHR despite its ratification in the country. The process incorporating a treaty into domestic law could delay international law from taking effect domestically. Now, I'll be addressing on the practical challenges of implementing international treaty obligations in both monist and dualist systems. Firstly, countries operating under these systems often follow different timelines for implementing treaty obligations. Both systems would result in delaying of implementation of a treaty. In monist systems, although treaties automatically become part of the domestic law, practical enforcement can still be delayed due to administrative or political factors. For example, the United States signed the UN Convention on the Rights of Child in 1995, but until today has yet to ratify it, due to political debates about its impact on parental rights and international sovereignty. In dualist systems, the process of imposing treaties into domestic law requires a legislative action. This can lead to significant delays due to the changes in government priorities. To illustrate this, the UK has been yet to ratify the United Nations Conventions on Contracts for International Sale of Goods, also known as the Vienna Convention, as ministers do not see this ratification of the convention as a legislative priority. There are other bills that are currently debated in the Parliament covering employment, civil partnerships, company law, issues which ministers feel are of greater importance. Now, for cases of environmental agreements as in the question, I will analyze how monist and dualist systems influence the implementation of international agreements. In monist system, challenges usually arise when an international law comes into conflict with a pre-existing domestic law. For a monist system such as France, the delay on implementation of the Aarhus Convention, which is on access to information, public participation in decision-making, and access to justice in environmental matters. As a monist system, France automatically incorporated the convention into its domestic legal framework after the ratification. However, conflicts arose when the convention's provisions and France's existing environmental legislation. Article L124-4 of the French Environmental Code establishes a local commission for monitoring and information. This placed restrictions on public access to certain types of environmental information, such as industrial projects involving classified defense matters or trade secrets. This shows that pre-existing domestic laws can hinder the effective implementation of international environmental agreements. As for a dualist country like Brazil, it will require a separate domestic legislation to give effect to international agreements. This could result in significant delays or outright failures when implementing. Brazil ratified the Paris Agreement in 2016. However, under President Bolsonaro's administration, there was a significant political resistance to environmental commitments. This includes the reduced funding for climate inactivities and deforestation monitoring. This led to delays in satisfying the country's target after implementing the agreement. This shows the need for a strong institutional and political framework to ensure that treaty commitments translate into actionable domestic policies. Due to the challenges faced by both monist and dualist systems, the timeline of implementation of treaty would vary depending on the country's system. For agreements like Paris Agreement, achieving global climate targets depends on synchronized efforts by all participating nations. When some countries implement measures quickly and others delay due to legislative, administrative, or political challenges, the overall progress toward emission reduction will be hindered. Delays by one country can have a ripple effect, especially if the country is a major emitter or plays a key role in global supply chains. If a major emitter like Brazil delays implementing deforestation controls under the Paris Agreement, the overall target of limiting global warming to 1.5 degrees Celsius above pre-industrial levels becomes harder to achieve even if other nations are compliant with the treaty. On the economic side of the issue, delays on one country implementing, for example, the Paris Agreement, of transitioning to renewable energy may cause other nations to slow down their transitions to avoid economic losses, which causes a cycle of inaction. This is because countries that act quickly on this matter may face disadvantages such as higher costs for adopting cleaner technologies, while delayed countries continue to benefit economically from cheaper polluting industries. Global climate systems are interconnected, which means that the delay in one country can negate the action in others that provide a positive impact. For example, deforestation in one country can increase atmospheric carbon levels, which acts against emission reduction achieved elsewhere. This lack of coordination weakens the collective efforts to limit global warming to the agreed threshold. For an environmental agreement to be effective, implementation of these treaties should be in accordance to the agreed timelines so that it can create a consistent progress towards global goals. The different system in countries prevent this from being effectively implemented. However, in executing the monist and dualist system in real life, countries don't strictly follow either models. There are often inconsistency between what their constitutions say and how international is applied in practice. This is mainly due to the involvement of the judiciary in issues concerning conflict of domestic and international law, on issues of how to interpret the international law that could be applied domestically. The United States is to be considered a monist country according to the Constitution. However, in the case of Massachusetts and Environmental Protection Agency 2007, the EPA failed to regulate greenhouse gas emissions, and the court held that the Clean Air Act applied to the carbon emissions because the law definition of air pollutant was broad and should include greenhouse gases. Therefore, the EPA could not keep delaying its decision on regulating these gases. This case shows that despite the US Constitution suggesting that it's a monist system, in practical circumstances, in this case, the court focused on domestic law, the Clean Air Act, rather than directly applying the Paris Agreement or other environmental treaties. So, given the challenges faced in both monist and dualist system in implementing international climate agreements, there are a couple of recommendations that could enhance the situation. Firstly, we could establish a unified international framework with flexible implementation timelines, where it can set global goals as a whole while also allowing each country to implement them based on their legal system. For example, like in a monist system, they could ensure that automatic incorporation aligns with the pre-existing domestic laws before signing of an agreement. This could avoid legal conflicts. As for a dualist system, they could provide guidelines on how to enact domestic legislation to incorporate a treaty obligations with a reasonable deadline. Furthermore, we could establish a global accountability mechanism where the countries are able to review each other's progress so that the states are able to improve their compliance to avoid international criticism. This creates a form of diplomatic pressure. Accountability mechanisms could also include enforcement measures such as sanctions, penalties, or restrictions for non-compliance. International organizations could establish transparent reporting and tracking systems. These systems would require states to regularly submit progress reports on their efforts, challenges in implementing the treaties. For example, the recently established Enhanced Transparency Framework under the Paris Agreement, where countries will report transparently on actions taken and progress in climate change mitigation, adaptation measures, and support provided or received. For my conclusion, the difference in implementing international law between monist and dualist legal systems significantly affects the effects of multilateral environmental agreements like those addressing climate change. While monist systems has more automatic incorporation of international law, there can still be conflicts with existing national laws. Dualist systems, on the other hand, encounter delays due to the legislative process required to implement treaties, further accompanied by a shifting political priority. Both systems must navigate practical challenges such as inconsistent timelines which undermine global climate goals. Climate change demands urgent and unified action, and aligning international agreements with domestic policies is critical to its